Hello, I'm Mike or Taz if you prefer, and on behalf of Jester Politics, Dr. Sean and Deb, I'd like to welcome you to Civil Liberties in the States, Jester Politics' fourth video in our series on the Constitution. As an initial matter, I'd like to point out that neither the Constitution nor the Bill of Rights grants Americans any rights. Instead, what it does is list our natural rights that the government is prohibited from infringing on. What are natural rights, you ask? Well, that's a good question with a simple answer. Natural rights are just rights that every person is entitled to by virtue of being born. It was a concept that was developed by the Enlightenment era philosophers such as Locke, Hobbes, Rousseau, and Montesquieu, all of whom had a significant influence on our founders. You can see their ideas in the Constitution itself, the Declaration of Independence written by Jefferson, the Virginia Declaration of Rights written by George Mason, and of course the Bill of Rights written by James Madison. As you'll recall from our last video, many of the states conditioned ratification of the Constitution on the demand that a Bill of Rights be added after the Constitution was adopted. And true to his word, Madison in 1789 submitted 17 amendments to the first Congress. Of those 17, Congress referred 12 to the states, and of those 12, 10 were adopted, and those 10 are now what we call our Bill of Rights. Initially, the Bill of Rights restrained only the federal government and had no application to the states. For example, the first and second clause of the First Amendment states Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. However, at the time that the Bill of Rights was adopted, 8 states had established religions. Additionally, if there was any doubt that the Bill of Rights restrained only the federal government, that was resolved in 1833 when a unanimous Supreme Court ruled in Barron v. Baltimore that the Bill of Rights restrained only the federal government. However, all of this would start to change with the ratification of the 14th Amendment in 1868. Though it would be a slow process, the 14th Amendment would result in almost complete incorporation of the Bill of Rights to the states. Or in other words, now the Bill of Rights, for the most part, with a few exceptions, does apply to the states. Now I know y'all are sitting there thinking, oh, come on, Taz, how can the 14th Amendment incorporate the Bill of Rights to the states? Well, that's a good question with an easy answer. In Section 1 of the 14th Amendment, clauses 2 and 3, the second clause states, no state shall make or enforce any law which shall abridge the privileges or immunities of the citizens of the United States. And the third clause states, nor shall any state deprive any person of life, liberty, or property without due process of law. The second clause is known as the Privileges and Immunities Clause, and the third clause is known as the Due Process Clause of the 14th Amendment. The first attempt to extend the Bill of Rights to the states came about in what's called the Slaughterhouse Cases in 1872, which relied primarily on the Privileges and Immunities Clause of the 14th Amendment. And the Supreme Court just quite literally shut that down. They didn't even want to hear it. It would be another 25 years before the first successful case came before the court in which we extended some of the Bill of Rights to the states, and that was in Chicago, Burlington, and Quincy Railroad v. the City of Chicago in 1897, and that involved a taking claim. However, instead of overruling slaughterhouse cases, the Supreme Court decided to rely on the Due Process Clause of the 14th Amendment instead of the Privileges and Immunities Clause. In this way, the Supreme Court could sort of skirt around the slaughterhouse cases, which, to be quite frank, was very poorly decided without overturning it. Additionally, instead of incorporating the complete Bill of Rights to the states, the court decided to follow what's become known as selective incorporation, which, to be quite frank, is the piecemeal incorporation of the Bill of Rights to the states. Under this doctrine, the Supreme Court incorporates or requires the states to follow the parts of the Bill of Rights that they view as fundamental rights. Under the doctrine of selective incorporation, the Supreme Court has incorporated those parts of the Bill of Rights that protects our natural rights to the states. However, they have done so in an unconscionably slow manner. Remember that the 14th Amendment was ratified in 1868, and the first case that was successful in extending protections of our natural rights to the states was in 1884. 1964. The nation would have to then wait until 1925, which was 41 years after the initial case, before the court would extend protecting our free speech rights to the states. The last case that the court heard where they extended our protection of our rights to the states was in 2019, when they extended the prohibition of excessive fines to the states, which I find unconscionable. And even today, the complete Bill of Rights has not been extended to the states. The Third Amendment dealing with quartering of troops in civilians' homes has not been extended. The Seventh Amendment dealing with right to jury trial in civil cases has not been extended. The right to indictment by grand jury has not been extended, nor has the Ninth and 10th Amendments. To be fair, the Ninth and 10th Amendments, I'm not sure are rights that can be extended. In any event, it's impossible to get around the conclusion that it's been 156 years, assuming my math is correct, since the 14th Amendment was ratified, and we still do not have all of our protections extended to the states. In fact, the Second Amendment was not even incorporated to the states until McDonald v. Chicago in 2010. I don't know, maybe I'm wrong, but I just find it unconscionable that it's taken over 150 years to extend the protection of our individual rights to the states. And with that, I'll wrap this video up, and we'll pick up next with free speech and the First Amendment. Have a great day, and thanks for tuning in. Bye.